Good afternoon. Please be seated.
Good afternoon.
Okay, we're here in case C-18-333-684-1, status check and defendant's request for his release on his own recognizance.
Good morning, Your Honor. Good afternoon,
I know.
Mr. McDonald, he's president of custody.
Good afternoon.
Mr. McDonald had been out of custody. There was no allegations that he committed any additional crimes or that he was a threat to the community. He was remanded into the custody in this particular case on a bond surrender. Now that we've been to trial, or so at least picked a jury, and through no fault of Mr. McDonald's, a mistrial was had, I'm going to ask the court to release him on his own recognizance. As an officer of the court, this morning, Judge Israel, sua sponte, indicated that he wanted Mr. McDonald to interview for mental health court, so we did not have formal sentencing had on the other case. Though we did begin arguments and got a little contested, but Judge Israel sent him over for evaluation for mental health court.
All right. I did review your written motion. I'm assuming this is just a typographical error. It says that probation is, or parole and probation is recommending probation. Is that just a...
That was the recommendation on the companion case we had.
Oh, on the companion case. Okay.
I had very little time to get that done, and I dictated a motion to my staff over the phone, so I apologize.
Oh, that's okay. I just wanted to clarify for the record.
The recommendation on the companion case was for probation.
All right. And to clarify, what was he convicted of in front of Judge Israel?
We went to trial on that case, Judge, and as a result, we ended up with a lot of convictions. We did get a not guilty on one. We got convicted basically of filing a false affidavit, a financial record of, and I don't want to misspeak. My memory's not as good as perfect. Burglary for entering the courthouse to file a document, filing a family court. Okay, thanks, Mike. And filing other false pleadings in family court. In this case, and I'll say this without a touch of irony or emotion here, was that case the most unusual case I've ever handled. It appears to be from his efforts as a pro litigant in family court.
Okay. All right. Thank you. All right. I'll have the state respond to the motion for his release.
Your Honor, I do not believe that good grounds have been demonstrated by the defense, nor when you look at the totality of the circumstances, does Mr. McDonald appear to be in any way, shape, or form an appropriate candidate for any kind of own recognizance or reduced bail. The history and circumstances of the cases which put him in custody, because they're unfortunately intertwined, given that Mr. Mueller is representing a bond surrender occurred, which is why he's in custody in this case, is that over the past 2 years he's been in and out of jail. He's been in and out of jail because he violates court orders on a regular basis, that he's been convicted of violating protection orders, multiple counts of that, domestic violence, specifically restraining orders, harassment, things like that nature on his ex-wife. His ex-wife is the victim here in our case.
Okay.
In addition, when he did get in trouble in those cases and sentences were imposed, they were imposed for a reason, because he was continuing to offend. And then in one particular instance in the municipal court, when he was having a sentence imposed, he started fighting with the marshals, for which he got a resisting officer charge, which he was convicted of and did another 90 days on. Then, several months ago, when he was arguing his bail status, and we actually had to put a motion on remand based upon some very unusual behavior by the defendant, specifically him trying to contact people associated with the case, him running into myself and Ms. Mishler in the street and trying to confront us about maliciously prosecuting him trying to attend some of our office's CLE functions and then stealing the calendar and saying he would be back, as well as, again, harassing the victim in this case by sending Amazon packages to her house, supposedly under the guise of presents for her children, even though it was on her birthday. We did a motion to remand. When Judge Kathy Hardcastle, senior judge, did remand him, and she was also familiar with his family court history, which includes him coming to the court, representing false statements to the court, him ultimately now being convicted for doing so in Ms. Mishler's other case against him, and then other unusual things like wearing a bulletproof jacket to the court, which put everybody on alarm, because nobody knows what somebody's going to do who has that. It's a secure space. Unless you're planning on doing something where you're going to get gunfire thrown at you, you shouldn't have anything to worry about in the courts. But that's what this man has done. And then when he was remanded after Judge Hardcastle did this, and both of these incidences are online on YouTube, having been videoed, he fought with marshals again. For reasons that are unbeknownst to me, when Mr. Mueller says, oh, this is the most unusual thing ever, I have no idea whatsoever why the 8th Judicial District Court did not pursue resisting charges on a man who's on video resisting marshals, yet again, who's already been convicted of it. It seems ludicrous to me, but he did it. Where was that? Judge Israel's department, which is 15 C's and C's.
Okay.
Now, regarding this morning, Ms. Mishler argued for prison. She asked for 24 to 60 months in front of Judge Israel. She made a similar argument as to what I'm telling the court today, much more lengthy, much more detailed. And ultimately, Mr. Mueller disagreed with that. He believed that he should get probation, and Judge Israel had both parties approach the bench. I wasn't there, but from what happened from the aftermath of it, Judge Israel was contemplating potentially having him assessed for mental health court. What was verbally heard by everybody in the courtroom is Mr. McDonald does not believe he wants to participate in such a program. My understanding of mental health court is you have to want to be able to do that to be accepted.
That's correct.
I think that it would be extremely irresponsible for this court or any court to release a person where the judge is teetering on this man has mental health issues, mental health court is where I'm leaning, and just release him to the street with any kind of support system or circumstances which would protect the community or himself from his actions. His actions are well documented, they've been well publicized. He is a dangerous person. And there's nothing in place, and there's no reason to justify releasing this man for any particular reason. Certainly what occurred yesterday in Your Honor's department is disappointing, but it is not in the hands of Mr. Mueller. It was not in the hands of the state. It was something that occurred happenstance by a misrepresentation on the part of media, not disclosing that this thing was being live streamed, and certain witnesses watching it, and then one of them being motivated by what he heard Mr. Mueller saying, late disclosing some evidence. Your Honor did rule that the media thing by itself was not the basis for the mistrial. It was the late disclosure of evidence.
Yes.
So based upon that, I don't think anything here has actually changed. Judge Israel was also very explicit. This man is to remain in custody during the period of the eval. He was not being released, even though there was some attempt to try to relax his custody status this morning. So for the aforementioned reasons, I would ask this court not to do anything to adjust his bail and leave it where it is.
Thank you.
McDonald
Mr. Mueller.
was originally charged with one count of domestic violence. The case was so severe that the city attorney agreed to dismiss it as long as he stayed out of trouble. Mr. McDonald's ex-wife has appeared in every criminal proceeding, and then surprisingly, after the stay out of trouble order was in place, suddenly his ex-wife now claims that she violates it, and Mr. McDonald gets remanded into custody. Now, he's not the victim of a crime, he's a victim of a very sharp family court lawyer. Then when he's in family court, now he's in custody because of what the family court lawyer has done, they go in and they take in sheriff's sale his house. He's now barred from his children, he's lost his house, he was wrongfully convicted. And even then, he's not been violent to anybody, he's resisted on occasion where he's frustrated beyond redemption. This is literally the most unusual case I've ever seen. Is a bunch of people picking on one guy who doesn't have a lawyer down in family court. Now, he hasn't violated any orders in front of this court. He hasn't had any trouble with anybody other than when they remanded him in the custody the one time, and he hasn't seen his kids. And I want you to understand, Kathy Hardcastle and I, Judge Hardcastle and I have a 30-year history. I've prosecuted against her and defended against her. She stood up and remanded Mr. McDonald into custody for sending his kids a Christmas present through Amazon.
In violation of a court order.
It was, respectfully, we didn't litigate it. It wasn't really violation of the court order. The paperwork was subsequently later amended. We didn't go back to that. All right. All right. Now the reality is this man has been rough treated by the legal system. Have you ever seen a wiretap charge? I'm sorry. I know you made.
I actually have.
Well, yes, in federal court you would.
Yeah.
Sorry.
Yeah.
All right. I'll have to rephrase my statement. Have you ever seen a state court wiretap charge?
Being on the bench Since April, no, but I know
And
that is
I
a
assure
charge.
you-
And I assure you, when I was a prosecutor, we had to confirm when we were taking cases, there was a federal involvement as to not violate the state prohibition against two-party consent, as it's only one-party consent in the federal system.
Listen, Your Honor, respectfully, Mr. McDonald, this is the first I've even heard of a state court wiretap case ever, and it is a direct outflow of his divorce proceedings. Yet again, this case will eventually end in a not guilty. Well, it probably almost certainly is going to have to be tried. Having said that, I'm going to ask to reinstate him on own recognizance. Judge Israel's got the keys to the case anyway down the hallway, and we're going to go get him interviewed for a mental health court. This was not his fault that this case didn't get resolved today, this week.
All right.
We are on the record in the matter, case D-505.
You guys either agree or I order.
I don't hear anyone saying she can't order a change of custody if she follows the right procedure.
There must be an evaluation of this interest.
You're going to convince me to hold your client in contempt.
Raise your right hands, face the court clerk to be sworn.
Even judges get contempt from all the time.
I find you in contempt. I am going to incarcerate you.
As I noted, I have reviewed the motion filed by the defendant and listened to the oral arguments of the defendant by his counsel as well as the state. Mr. McDonald, your attorney rightfully points out the factors I have to consider. Thank you, I'm a little short, so thank you for standing up. I have to consider when I'm considering release at any time, whether it's at the time of arrest or later for motions. They include things like length of residence in the community, the status and history of employment, and relationships with family members. So the first two of those three adhere to your benefit. You have a long time in this community, you had stable employment up until recently. Obviously, your relationship with your family has taken a turn that seems to not go well and seems to get you into more trouble. So that doesn't bear in your favor. I also have to consider your reputation and character and mental condition, your prior criminal record, including any failures to appear. I don't believe there are any failures to appear. Am I correct on that?
I believe that's correct.
All right, which does adhere to your benefit. I also have to consider the nature of the offense in which you're charged with, the probability of conviction, and the likely sentence as it relates to the risk of not appearing, and the nature and seriousness of the danger posed to the victim or any other person in the community should you be released, likelihood of any more criminal activity by you if you were to be released, and last but not least, any other factors concerning your ties to the community or bearing on the risk that you may not appear. So the last half of those factors are where you hit an uphill situation. Understanding that you didn't violate a court order in this case, you have repeatedly violated orders of the court, not only before Judge Israel, but as I understand in terms of family court. Now, you can disagree with that, but in the end, it's something that I have to consider. And when I hear that and I see that, my concern is that I could give you any order and you would defy that because you have a history of doing so. I'm also very concerned about the safety of the community and the alleged victim in this case. Your behavior of contacting the victim, approaching the prosecutors, providing false, you were convicted ultimately, and so 12 people convicted you of making false statements, or was it perjury or false statements, or both?
It was both, Your Honor.
All right, of
3
both.
counts of burglary, 3 counts of forgery, 2 counts of offering, filing,
All right.
false document for record, 2 counts of perjury, 10 felonies.
Okay. All right. Thank you for that. And so those are multiple crimes of dishonesty that weighs against you. And you have a history of engaging with the marshals when they try and take you into custody. So that, weighing all of those factors, I do believe that remanding you to custody.
Judge, can I
Hold on. Let me finish my announcement here, okay, and then you can talk. I do remand you to custody is the right thing to do. We could talk about bail, but I think remanding you to custody and staying in custody is the right decision. So I'll hear from you now.
Judge, I already posted bail on this before. I was out for 90 days. I haven't gone anywhere near my ex for the past 3 years. I have a lot of ties to the community. I have a lot of good family here. My breakdown between me and my ex-wife is, it's just that I've been staying away from them. I just want to see my kids, Judge. And it's been pretty soul-ripping not to be able to see them. So I stayed far away from her. I followed all orders to the T. Yet there was some contradictory orders at family court that were unfollowable, Judge, that was put on, that superseded the TPO that was put on the divorce decree that said I could have reasonable phone conversations, which now isn't in before you hear, which I actually did 6 months for her recording me and wiretapping me. But Judge, I followed all the orders that I could to the best of my abilities. I've gone nowhere near her, and I will not go anywhere near her. I just want to be out and just be done with all this stuff and move on with my life. So I appreciate you consider that.
Well, I hear you, and I think that I think when you're saying that to me, you genuinely want to do that and want to comply with the court orders. Unfortunately, issues of the heart make people behave in a way that can be dangerous. And when I say dangerous, I don't mean that in a necessarily violent way, though it could lead to that. I say dangerous in a way that it could also mean you get yourself into more trouble. One of the things that I don't ever like to do, whether I'm putting somebody on probation or remanding them to custody or deciding to release them, is set them up for failure. And I think where we are right now, I think a mental health evaluation is appropriate. I think, I don't know if you're willing to participate in that program. It does require a willingness to participate, and if you don't, you would violate that condition. And so I think that is the right decision as we sit here today.
I have a psychologist, Judge, that I've been seeing in order to be able to take those steps to see my kids.
I think that's good news.
I've also was off of an ankle monitor and been on an ankle monitor, gone nowhere near her whatsoever. I did send presents to my children, Judge. It was Father's Day, my son's 8th birthday, 6/16, and then I get thrown in jail. I was out on a $100,000 bail in another case, and then $15,000 here. I'm completely out of money, Judge. I've gone nowhere near her. I'm not going to go anywhere near her. I just want to be done with this case and have some resolution and be able to prove that, get back to work, and then eventually be able to see my children.
All right. Well, again, like I said, I think when you're saying those words, you genuinely mean it. You are in a different position than you were when this bond was initially entered, because you had not been convicted in the case in front of Judge Israel. You have since then been convicted, so that changes your criminal history. The initial bond that was set in this case was $15,000. that has been surrendered. Let me turn to the state. Are you requesting a no bail hold?
Yes, Your Honor, or maybe an alternative, a bail of about $100,000. When that bail was originally set, in this case, way back, we're going back maybe 2 years at this point, we had none of these things that we were arguing today at our disposal. This was just a guy who committed these 5 felony counts, and we had no idea what else he was capable of or what he was going to do. We're in a far different position today than we are back then, so I would ask for a no bail, or in the alternative, $100,000. And certainly there should be requirements with that bail, because my understanding is either his mom or his family member's house is exactly 1 mile or less from our victim's place of work. And I believe a family member of his actually attends the place, it's a high school. And one of his brothers is a student at that school. So it's a very difficult and trying situation for our victim.
The state constitution does not allow no bail holds, except for murders. And my colleague seems to understand something. There's not a crime of violence here. The one crime of violence that he was accused of was domestic violence. The city had initially agreed to dismiss. It was so inconsequential.
Then he had two run-ins with the marshals.
Yes, he did tussle with the marshals. He didn't punch them. He didn't kick them. He just kind of passively resisted them the first time they went to the ground. I'm not walking away from that, okay? It wasn't very wise, but at least I understand his frustration. Now, he's been rough-handled down in family court. Whether any of those convictions actually stand or not, we'll see what the appellate courts want to do. But on aggregate, my colleague keeps standing up and saying, dangerous. He's not dangerous. He's in his mid-30s or early 40s with 0 criminal record until he got sideways down in family court. Now, in a very real system, in a very real sense, and I say it like a touch of irony, this system has turned him into a criminal. Now, they've stolen his house. The wife has stolen his house. She's hysterical mongering. You should see these letters. If he had been the shooter on the grassy knoll, they would have written it in the letter. Now, these are non-violent. This is a non-violent offense. The only person's word we're going to have to take from it is people who demonstrated that they have hostility towards him here on this case. Wiretapping. The state won't even be able to show that this wiretap was done in the state, if it was even a wiretap at all. Respectfully, Judge, he's entitled to a reasonable bail. I'm going to ask for, if nothing else, to reinstitute the $15,000 bail. And $100,000 is disproportionate, violates the state constitution on reasonable bail. And the bail is only, it's not punishment, it is to determine and make sure he's returned to court. He has never missed a court date. In fact, candidly, it might have been better on a couple occasions if he had missed a couple court dates. But the reality is he's never missed any court dates either. And he actually does have a history of being involved in community projects, and as the court's aware by now, he's tied to a couple of very prominent families here in town. He's not going anywhere.
Maybe one clarification, Judge?
Yes.
With regard to the last comment said by Mr. Mueller, his ties to very prominent families would be the Bonaventuras. With regard to his earlier remarks about nobody having been charged with wiretaps, I have an open trial on Mr. Bonaventura for said charge. I have multiple cases where people are being charged with doing the very conduct Mr. McDonald is, and it isn't lost on anybody that is his family member who's doing the same criminal conduct. So these are the people who were around him when he was committing these crimes. I don't think having them now should make anybody feel any more comfortable.
All right. What is the case number in front of Judge Israel? Do you have that handy?
Did bring a file to
It's C335284.
2335. Can't read my own handwriting, all right.
The next court date on that is November 13th. That is the status check to determine some outcome on the mental health board evaluations.
All right, I'm looking at the PSI for that case. I do think it's relevant to my determination here. I'll note that the PSI states the defendant was diagnosed with an adjustment disorder due to his divorce. And I'll also note that he has multiple misdemeanor convictions, a 2016 violating restraining order, the same for 2017, the same for 2018, and then the 2018 resisting public officer. He had also been charged with a number of offenses which he has not been convicted for. They were dismissed: domestic battery, burglary, forgery, and offer false instrument of public offering. It seems like that might have been incorporated into the ultimate case before Judge Israel. There's also a modified protection order in place. Has that been extended? It looks like it was set to expire October 3rd. Do we know?
The protective order in family court,
Mhm.
I believe it was extended, but I'm not 100% certain.
Okay, all right.
It was extended, that was the document I was telling you about, that's
Okay.
when they added no contact or no gifts for the kids.
Understood, thank you.
That's we didn't litigate that, but.
Understood.
McDonald was something, received an injustice on that.
All right. Okay, so I am going to issue a bail. It will be $15,000 per count. So that's going to be a total of $75,000 bail in this case. If the defendant is able to make bail, he will also be subject to house arrest and high-level electronic monitoring. I will also issue a stay-away order from the alleged victim and their minor children in common. He is to have no contact with the victim or their minor children, either direct or indirect. To the extent that family court modifies that order, then this order will mirror the family court order, so they are consistent. Does the state ask for any additional conditions?
No, Your Honor.
No, I think that's sufficient.
We invoke a speedy trial right then. There's zero chance it's gonna make 75,000, Judge, so we can get the trial set as soon as possible.
Your Honor, with regard to your earlier question about additional conditions,
Yes.
if we could have a specific order to stay away from Bonanza High School, that is the victim's place of employment, which is very close to defendant's mother's house.
Yes, there'll be a stay-away order from Bonanza High School. The defendant cannot be within, is 1,000 feet sufficient?
Yes, Your Honor.
All right, 1,000 feet of Bonanza High
I know
School.
that when the court pronounces specific places, then the house arrest unit will input those in the device and it will trigger. With regard to defense's request for a speedy trial right, there's no state-recognized right for re-invocation. However, if he wants a trial sooner than later, certainly within our calendars, we can try to accommodate that.
Yeah, we can set it as soon as possible. When's our next trial staff? Our next trial strike is in January.
That would be sufficient.
Mr. Mueller, how's your calendar looking in January?
I'll make this work, Judge.
All right, we can set it early, our earliest possible setting.
January, December 18th, calendar call, January
Melissa,
6th.
Mike, stop. Calendar call.
December 18th, calendar call, January 6th.
All right.
Calendar call is at 8:30 in the morning, trial is at 9:30 in the morning. All right, thank you all for being here this afternoon, I
Thank you.
appreciate it.
We appreciate it, and our experience in the limited amount of trial was pleasant, so thank you.
Oh, thank you. Well, it was a pleasure to have everyone before the court. Thank you.
There's no
Judge,
mechanism.
I'd like to bring back the trial, please, Judge, with the same jury. This is ridiculous. I'd like to invoke my right.
Well, the mistrial has been declared and we can't undo that now. So we will, we do have a trial day set for you, and we'll get you tried as soon as possible. Thanks, everybody.
Thank you.
Your Honor.
Officer,